Welcome back. I'm Neil Dailey with McGraw Commercial Properties. With me, Rich Marshall of Connor Winters, our resident attorney here for all things commercial real estate. Rich, thanks for being on again. Round two. This week is something that I think even seasoned veterans in the commercial real estate business have questions about, because this is a point in the transaction where things get handed off and it goes into some magic factory and then makes the closing happen at this point, right? So we're talking about abstracting title insurance, abstracting, understanding what title insurance covers, what it doesn't, why you need it, all that stuff. So what is an abstract and why do we have it? So very basics.
Yeah, so first of all, thanks for having me back on, Neil. The abstract is basically a compilation of all of the historical documents that have affected the property, typically since statehood. Sometimes they go prior to statehood. But it's a big stack of documents that is, again, it goes back to everything that affected title of your property 60, 70, 80 years ago.
Okay.
And the process that takes place is once you are, let's say you're a buyer and you're looking to acquire a piece of property, they're going to do what they call bring the abstract current, which means they're going to take that existing compilation of all the documents, and then they're going to go to the county courthouse and search the records to see what else may have been filed against your property since the last time the abstract was updated. And that's called bringing the abstract current.
So they do something called a UCC search?
No, the UCC search is a little bit different. The UCC search is something that is typically for judgment liens and tax liens and things of that sort.
Right.
Those are typically done not at the county level as much as at the Secretary of State level.
Okay.
So the UCC search is something totally different from the abstract search.
Okay. So two parties agree to sell a piece of property, contract gets turned into the title company. Title company puts out a search for that abstract, which is that compilation of documents that establishes the chain of title. From, I've seen very old ones, huge stacks of stuff that go all the way back here in Oklahoma, especially where it was the U.S. government granting it to, for example, the Osage Indians.
Correct.
And then every time it's been sold since then. So
right.
They find that document's generally stored at some sort of abstract plant, right? Am I right so far?
Mm-hmm.
All right.
Yep, you're on.
It gets, I don't even need you.
Don't need me here.
So the abstract gets delivered to the title company. An attorney such as yourself would then review the chain of title, correct?
Yeah, so what happens after the abstract is brought current, again, that's when the title company has gone out and researched the records again and brought the abstract current to date. Then they'll take it to an attorney. And typically you have attorneys that really specialize in rendering title opinions. And what the attorney will do is they'll render or write what's called a title opinion, which is basically their analysis of the abstract, and the opinion will basically set forth what the lawyer sees as still things that affect title, for example, easements or any types of restrictive covenants, things of that sort. And at that point, the title opinion that's rendered by the lawyer is then delivered back to the title company. Right. So that's step one in the deal.
That is then called, once they own that opinion, that's called the title commitment, correct?
No. So what happens? So in Oklahoma is a little interesting. It's a little bit different than other states. You have the option in Oklahoma, let's say you're a buyer, you have the option just to rely solely on the title opinion. So you could stop right there. You could say, okay, I'm just going to rely on the title opinion and I want to close based on the lawyer's opinion to me as to what affects property. I feel comfortable what the lawyer told me affects property and I'm good to go and I can stop there. The other option that's available in Oklahoma is you go to step two, which is you elect as the purchaser, say, I actually want a title policy. And that's an insurance policy that you can obtain through the title company. So if you go to option two, which is recommended, we can discuss about it further, but when you go to option two, what the title company will do is they'll take that title opinion from the lawyer, and then they, at the title company, will convert it into what's called a title commitment.
Okay.
And the title commitment is basically, just as it kind of sounds, it is the title company's agreement to issue a policy based on the title commitment if they are paid the title policy premium at closing.
Right. And there are certain check marks and benchmarks that have to be met in order to commit to that title. Otherwise, there would be an exclusion.
Correct. So yeah, a great example would be if let's say the title opinion says, oh, there's a problem with the deed, or there's a major problem with the legal description, then at that point the title company is going to say, okay, that needs to be cleaned up before we could render you a title commitment. Because again, the title commitment is almost like their promise to issue coverage if and when closing occurs, assuming they get paid the title policy premium at closing.
Okay. So you've got the title commitment. The title company has reviewed the opinion. It is now made so that a surveyor could take that updated, confirmed legal description, survey the property generally with, and I guess there are multiple ways to do that. The most common one that I see is an ALTA survey, or American Land Title Association survey, with a set of check marks. Surveyor goes out, plats everything out. Platting, that's a bad term.
Oh, that's fine. Yeah.
Maps everything out according to the property boundaries, and that legal description gets that back to the title company, and they look at it to make sure that everything's correct.
Yes. So there are a couple things you can do. You do not have to actually have the survey to close as a purchaser, but it's strongly recommended.
Okay.
Because the title, either the title opinion or the title commitment, whichever way you go, it only tells you the written word. It tells you, oh, you've got a railroad easement that goes across your 20 acres.
Okay.
But oftentimes it does not describe by visual depiction where that easement sits. So that's where the survey comes in. The survey is able, if that easement is plottable, which means it has a good legal description in the easement document itself, the surveyor can read that legal description in the easement document and then put that visually on the survey, so you'll know exactly where that railroad easement runs across your 20 acres.
Right.
So it's always, when we're representing buyers, we always want to recommend you get the survey in conjunction with the title commitment, so you have the written word, but you also have a visual depiction of where things are. Now, as you know, there are some things that are of title that you can't plot, unfortunately. So, and utility companies are notorious for this. What they will often do is they'll just kind of slap a utility easement on a property, but they don't describe where the actual easement area is. Basically, they say, we've got a right to place a utility easement on this 40-acre tract.
Right.
But they don't lay it out by meets and bounds as to where the easement area is. If that occurs, it's called a blanket easement. And unfortunately, in those situations, the surveyor really can't plot it because there's no really, as I just mentioned, no true easement area that's defined in the written easement agreement itself.
So that's something to log away, as if you're a buyer or a serial buyer of property, and especially land, a lot of times, rural land, maybe you're scouting farmland that hopefully turns into a shopping mall 20 years from now. That's something that you might commonly see, some sort of blanket easement, whereas there's less attention to it just because it's a wide open tract of 40 acres. And if we need to get on here someday, let's go with the vaguest, widest, broadest easement I can possibly get.
Yeah, and you bring up a great point there, Neil, because if it's, let's use a couple examples. Let's say you're buying an existing apartment complex that's been there for 20 years. There's less of a risk of someone walking in and saying, oh, hey, my blanket easement allows me to take this right through the middle of the apartment complex. That's
right.
A court would look at that and be, that's not a reasonable location of your easement. If you need the blanket easement, it needs to go in the corner, in the grassy area of the property. Right. So when you have a fully developed, improved property, the blanket easements oftentimes present less of a risk because you already know there's stuff on property. If, however, you're buying raw land and you're looking to develop that raw land in the future, sometimes your scrutiny has to be a little bit higher for blanket easements because you're like, okay, well, great, there's 3 blanket easements that affect this 20 acres I want to develop as a strip center. What you may want to do, and I've done this on occasion for certain clients, is you may want to go back to that easement holder to say, I need you to describe by physical meets and bounds the location that you want of your easement area. Let's agree right now where it is. So that way you followed record before you close and the surveyor can plot it. So now you have certainty as to where that easement is, so it won't hopefully adversely affect your intended use of the raw land.
And do it before you close and not after.
Absolutely.
The fact.
Yeah, don't do it after. Yeah, if you do it after, it's your baby, unfortunately.
That's right. All right. So let's talk about some of the benefits of title insurance. Every time that we're dealing with a seller that may not be used to repetitive, selling, maybe they've only sold one other property in their life, or none for that matter. They want to say, or let's change it to the buying side. There's always the option in the contract to check whether or not you want title insurance or not. And they say, do I even need it? Sounds expensive. I don't think I even really need it. What would be some of the benefits of a title insurance policy?
Well, you are correct that the title policy is going to have an expense. Oftentimes, though, in all contracts, that expense is negotiable. So you could, as a part of your negotiation, if you're a buyer, you could ask, for example, the seller to cover the base premium for the base policy, and then you, as the buyer, could incur the cost for any special endorsements or coverages you want. And that's a fairly typical approach in commercial transactions, is to do it that way, to have the seller kind of cover the base premium, and then the buyer, if they want extra endorsements and extra coverages, the buyer pays for the extras. But here are the benefits really of the title policy is, yes, in Oklahoma, you can, in other states, but let's just speak about Oklahoma, you could rely just on the attorney opinion. But what happens, let's say if the attorney missed something, or even let's go to another scenario, what happens if the abstract company just failed to properly compile the abstractor's report correctly? You would have to go and try to bring a suit against the lawyer for a bad legal opinion. And if for example, the defect was due to the abstractors not pulling the proper documentation to give him or her a current abstract report, the lawyer's got an automatic defense, because you can only really sue a lawyer on their negligence. So if it's the abstracting company's fault for not getting title brought current, you can't really pin it on the lawyer. But let's say, worst case scenario, you can try to pin it on the lawyer. Let's say the lawyer received the information, but he or she just didn't render a proper opinion. You have to sue them to try to get any kind of compensation for the bad title opinion. And as you can guess, good luck trying to sue a lawyer, right? I mean, lawyers are very good about trying to buffer and protect themselves, and legal opinions even sometimes have some nice wiggle room in them that give lawyers some leeway here and there to provide a defense if someone ever claimed they had a bad opinion. The other thing that's interesting to note and important for people to understand is lawyers, for example, in Oklahoma, are not required by law to carry malpractice insurance. So if you, for example, get a bad legal opinion from an attorney who has no malpractice insurance, you're hoping that lawyer's got some money that you could capture when you sue him or her. And reality is we're not all, I'm far from a multimillionaire. Most of us aren't multimillionaires. That's we're still working every day, right? So a lot of the lawyers that would render title opinions don't have a lot of financial wherewithal to support a claim that's brought against them. So you could get a claim against somebody and win in a judgment, but then you may not ever prevail on that judgment because you can't collect. So that leads us to the title policy itself. Yes, there is an added cost for the title policy, but it's not significant. It's not thousands upon thousands of dollars. Let me back up. It's a low threshold depending on your purchase price. For example,
generally percentage.
So I was looking just recently. I may refinance my house, and I think my policy for a refinance for my personal residence was like it's going to be maybe $1,000. So, and there are metrics. Anytime you're looking at doing a deal, you can always ask the title company, hey, how much is it going to cost me if I get a policy for $1 million commercial piece of property? And they're going to tell you, but I'll tell you the money is well worth it, because if there is a title defect, the title company stands behind their policy, and they have to have financial wherewithal in order to issue policies in the first place. So if there is a true title defect, you're going to have quick recourse against the title company for a damages claim. And you're going to be able to obtain those damages if, in fact, there was a title defect as far as their policy analysis occurred. So it's a safer measure. It just gives you more comfort as far as a buyer of property. And the other thing is an added benefit is that policy will kind of carry over or inure to the benefit of your successors. So, there are times when you're looking to sell the property, it's going to give that new buyer some comfort that, oh, you got a policy, at least I can rely on it. Or, typically we would recommend that the new buyer gets a new policy, but But as far as the diligence is concerned, it makes a new buyer feel comfortable.
Exactly. You're providing a clean deed, in other words, without any issues.
Yep.
So there's no clouds on the title. The title insurance, it is paid one time at closing.
Correct.
It's a
Yes.
lump sum payment, carries for as long as you own the property, correct? Or is there an
Yes.
expiration date?
No expiration date.
Okay.
Now, there's two important things to understand about title coverage. Is title policies are coverage for things that happened in the past.
Correct.
So it's not coverage that you would see, for example, if you got health insurance or auto coverage. It doesn't cover you for documents or matters that may be filed against your property 6 days after you close, 6 years after you close, 60 years after you close. So it's only tied to things that happened prior to your ownership that the title company did not discover during their title search and list on the title policy as items which we call exception documents.
Right.
So the title policy will basically say, we will cover you for anything that happened prior to your ownership except for these 8 or 9 things. And these 8 or 9 things are what we call title exceptions. So those are going to be, for example, an easement filed of record in 1953 or restrictive covenants filed of record in 1968. The title company is going to list all the things on the title policy that they will not cover you for if someone pops up and says, hey, I've got an easement across your property. They're going to say, okay, well, is it listed in the title policy as a title exception? If the answer is yes, you don't have coverage for it.
Okay.
But on the flip side is if there is an easement, let's say 20 years ago, that affects your property that the title company did not list in the title policy as an exception, you do have coverage at that point.
That's probably the most common thing that I have seen in my years of commercial real estate, especially around here with oil and gas line easements. Companies are bought and sold. Somebody doesn't get all the data when it's transferred. You know, it was XYZ company back in 1925, and then it's transferred ownerships, and there may not even be anything in the pipe, but they still have an easement right through the middle of it.
Mm-hmm.
So you got to track all that down, find out what it is, and maybe somebody missed it.
Yep. So let's just quickly say, let's say that there is actually a easement that is filed against your property that was not listed in the title policy as a title exception. And now you have a claim against the title company for failing to basically discover, if you will, that easement.
Right.
So you've got a damage claim against the title company at that point. The damages will be always the lesser of the amount of your title policy. Your title policy, if you're a buyer, is typically going to be your purchase price amount. That's going to be the max you could ever recover for that title defect.
Right.
It's going to be the lesser of
damages.
Correct. It's going to be lesser of that aggregate insurance coverage amount in your policy, or the actual damages you have incurred for that easement running across your property. So if, let's say in our oil and gas easement, for example, we find out there is that easement goes across the property, but it's determined by a court typically that the damages for that easement across your property are $100,000, but your title policy is $250,000. Then the only thing you're going to be able to recover from the title company is the $100,000 amount, because it's the lesser of the two.
Which is fair. That's the cost to fix it. They made it right, and now you can continue on with your plans.
Right.
Very good.
And the other thing I'll just mention, there are, separate apart from just the base policy, in all states there are what they call endorsements or extended coverages you can obtain for extra premium. So one of the standard endorsements in Oklahoma that you would get would be the survey endorsement, just like you mentioned earlier. Basically, when you get a survey endorsement to your base policy, the title company is saying, hey, we acknowledge this survey and we agree that everything that's on this survey is also what we see in our title policy. So if there's a screw up on the survey, we're going to cover that. So there are coverages you can get, and they're customizable depending on the transaction. So it's always good for you to talk with your attorney or the title company to kind of get an understanding of what endorsements may be good for this particular transaction.
Yeah, fantastic. All great information. And I know that there are specific examples that, if we had a classroom here and everybody could raise their hand and ask a specific question, we'd be here all day. That's what's happened before when we've talked about this, and somebody said, well, what about this? And somebody's fence was on the other side of the property line, and on and on and on. So all great stuff. If you do have a question that we didn't cover, or if it's something that you would like some more information on, please give Rich a call. Again, Rich Marshall, Connor and Winters. It is 918-586-8526 for the main line. Reach them directly at 580-220-8995. And then email at rmarshall@cwlaw.com. I'm Neil Dailey with McGraw Commercial Properties. Thanks again for watching another segment here on abstracting and title insurance. We'll see you again next time.